Whew, well, part one was a longer lecture than I intended. So thank you for sticking with me, and welcome to part two, where we are going to discuss agency discretion. Okay, so what do we mean by agency discretion? Discretion is the ability to choose between two or more actions, and that includes also choosing between action and inaction. And it is the first type of authority that agencies possess. So your policy analysis memo, due at the end of the semester, that actually will showcase agency discretion because you're actually going to be recommending that an agency take a certain course of action or make the decision to take no action at all. So agencies perform rulemaking and adjudicatory functions. They issue regulations and they hold sort of the administrative equivalent of a court trial. And agencies have discretion in carrying out these functions. So these functions can be formal agency actions, but as we will learn a little bit later in the semester, most agency action is informal. So it's not governed necessarily by a specific statute, or rather, it is governed by a statute, but that statute is vague and does not provide the agency with explicit instructions on how to operate. So without that statutory instruction, agencies have no choice but to exercise discretion. They choose between two or more options and decide what course of action to take. Now, too much discretion can lead agencies to act arbitrarily and do whatever they want because they're not constrained by law and policy. But on the other hand, too little discretion can be just as bad because it can lead to inflexible agencies and really grind the bureaucracy to a halt. So agencies have a lot of discretion if there are not enough rules that tell them what to do, because it lets them make up their own rules. And they also have a lot of discretion if there are too many rules telling them what to do, because agencies can't follow all of them, and just for practical purposes, they have to start discarding rules here and there. So for instance, think about OSHA regulations. That's the Occupational Safety and Health Administration. OSHA has so many rules that it's just not possible for OSHA inspectors to enforce every last one. Instead, the inspectors have to pick and choose to enforce the rules that they believe are the most important. So that is discretion, a lot of discretion, because of the fact that there are just too many rules. I want to talk about two different examples of IRS's exercise of discretion, both of which really inflamed public opinion. So first, the IRS used its discretion to not enforce a law known as the Johnson Amendment. So the Johnson Amendment is a tax code provision that says tax-exempt groups like churches and charities can't speak for or against particular political candidates. The Johnson Amendment was approved by a Republican Congress, and it was signed by a Republican president, Dwight Eisenhower. Now, the IRS routinely enforces the Johnson Amendment for charities, but not for churches. Now, churches can make political commentary or advocate on behalf of a candidate in the course of carrying out their ordinary activities, but that cannot involve an expenditure of funds. Or it can only involve a minimal expenditure. So for instance, during a sermon, a minister can speak about political candidates, but the church is not supposed to hold fundraisers for the candidate. And over the years, polls have consistently shown that majorities of both the general public and also the religious clergy oppose the concept of churches endorsing political candidates. So what this means is the public and much of the clergy actually are in favor of the Johnson Amendment. Even so, back in 2008, the Mormon Church invested really heavily to pass what was called Proposition 8 in California, and that, Proposition 8, and that banned same-sex marriages. The Mormon Church also campaigned really heavily when Mitt Romney ran for president in 2012. Right now, there are petitions and advertisements in Utah asking the IRS to revoke the Mormon Church's tax-exempt status. For a while recently, in recent years, The Johnson Amendment was hotly debated because President Trump vowed to destroy it, which he can't do because it's up to Congress. Opponents of the Johnson Amendment say that it stifles free speech, but keep in mind, churches and charities are still allowed to speak about issues, including political issues, in the course of their regular business. They just can't raise and give money to particular political candidates. People in favor of the Johnson Amendment say that a repeal would basically allow churches to act like super PACs. And again, polls show that Americans believe that clergy should not endorse candidates. In fact, in 2015, Lifeway, which is a Christian polling firm, found that 79% of Americans did not want clergy endorsing candidates during worship services. So for years and years, more than 2,000 primarily evangelical Christian clergy have deliberately violated the Johnson Amendment, basically as a form of protest against it. And only one has been audited by the IRS, and none of those organizations have been punished or lost their tax-exempt status. So that's a prime example of agency inaction. The IRS has declined to take action enforcing the Johnson Amendment. Second example is where the IRS used discretion to target certain political groups. Back in 2013, the IRS admitted that it was selecting political groups applying for tax-exempt status for extra scrutiny based on the organization's name or political themes. So at the time, then Attorney General Eric Holder ordered the FBI to investigate. And the FBI found that for 2 years, the IRS had essentially placed a hold on processing tax-exempt applications from organizations with Tea Party or Patriots in their names. None of these applications were denied, but only 4 were approved. Whereas during the same period, the IRS had routinely approved applications from other groups. So Republicans and Democrats in Congress, as well as at the time President Obama, agreed that the IRS had to apply the law in a fair and impartial way. So the IRS did not have discretion in this case. And because of that, a number of IRS officials resigned and some employees were fired. The FBI did eventually announce that it did not find any evidence of what they called enemy hunting. The IRS was not specifically targeting political groups with which IRS employees disagreed. But the FBI did say that IRS personnel were charged with enforcing these rules that they did not fully understand, and that is problematic. So there are 2 major benefits of agency discretion. Discretion injects some humanity into the process of governing. Public administrators are human beings, and so they are inclined to take into account human emotions and hopefully common sense. Second, discretion does allow for fairness in situations where you just can't foresee every possibility. Congress can't foresee every single consequence or issue that will arise from a statute. And so agencies do need discretion to deal with these issues as they arise on a case-by-case basis. However, too much discretion can create agencies that act arbitrarily and inconsistently. And that not only makes them difficult to control, but it also makes things very hard for business because businesses need a stable regulatory environment so that they understand what is expected of them. An agency's discretion, of course, is not unlimited. The Constitution creates the biggest check on agency discretion, which we will talk about in depth later in the course. In addition to the Constitution, the non-delegation doctrine, the implementing statute that creates agencies, and other statutes that direct agencies to carry out certain laws, these all provide limits on an agency's discretion. Basically, Congress creates a sort of sandbox in which agencies have to operate. And the Administrative Procedure Act is one of those statutes that limits agency discretion and other agency actions. The APA requires agencies to adhere to certain rules when they carry out their functions, and we'll talk about that momentarily. The President and Congress can impose additional restrictions or limits on agency discretion via executive order, the budgetary process, and the Congressional Review Act. Judicial review also operates as a check on agencies, but we're going to see in a moment that it is much easier to go to court to complain about an agency's action rather than an agency's decision not to act. And so the case of General Motors versus the Federal Energy Regulatory Commission, or FERC, this is a case of agency inaction. So in this case, FERC had issued order number 467, and that order prioritized the delivery of natural gas to individual consumers during periods of curtailment, when there were gas shortages. So under that FERC order, the very last customers to be curtailed or limited in their ability to get natural gas were residents and small businesses. And in this case, in the GM case, FERC decided specifically not to act, and they got sued. So the facts of the case involve a company called Pipeline, which distributed natural gas. The red line on the image on the lecture slide, that represents Pipeline's pipeline of natural gas. So along the pipeline, along its physical gas pipeline, the company Pipeline sold gas to utilities in various states. And those utilities resold the gas to residential and business customers. So one of these utilities was Northern Illinois Gas, NI Gas, which had GM as one of its customers. So NI Gas was reselling Pipeline's gas to GM plants in Illinois and other locations. So at the time, back in the 1970s, there was a big concern that we were going to run out of natural gas. And fearing that the country was running low on gas, FERC issued this order, Order 467, that said that the main natural gas suppliers, like the company Pipeline, had to have curtailment plans in place to conserve natural gas. And in the event of a shortage of natural gas, FERC said that companies had to give priority to residential customers. Basically, FERC did not want people to freeze to death while GM gobbled up all of the natural gas resources for its manufacturing plants. So in this case, FERC required that gas companies give priority to residential customers. Now, at one point, Pipeline thought it was going to have to cut back or curtail its natural gas supply. And as required by FERC, Pipeline filed a curtailment plan. That plan had an impact on NI Gas's ability to distribute gas to its customers. And that, in turn, affected GM's plants. So GM went to FERC and said, you can't do this. It's got too much of an impact on our business. You, FERC, should have had a formal adjudication, meaning a hearing of some sort, before approving the curtailment plan. Now, in this case, FERC actually had issued notice to the public and it allowed public comments, but it decided it was not legally required to hold a hearing. So here, FERC decided not to take an action. It allowed Pipeline's curtailment plan to stand. And so GM sued in DC court, DC Circuit Court. And the court basically said, sorry, GM, but if an agency decides not to act, the courts cannot step in and tell the agency that it must act. So if an agency action causes harm, that's a lot easier to challenge in court than an agency inaction that causes harm. Two other limits on agency discretion are the non-delegation doctrine and an agency's implementing statute. So why do agencies have the power to issue regulations which have the force of law? The answer is, because Congress gives them that power. But there is a doctrine, the non-delegation doctrine, that says that because the Constitution vests all legislative powers in Congress, Congress cannot delegate those powers to another branch of government. So in that case, how is it that Congress can delegate to agencies? Well, Congress is allowed to, quote, seek assistance from another branch. and Congress often seeks assistance from administrative agencies in the executive branch. And part of that assistance is calling upon agency expertise to issue regulations that fill the gaps in laws passed by Congress. There are limits, though. Congress cannot just hand over its powers to an agency. It must provide what we call an intelligible principle to guide the agency, and the agency must act consistently with that intelligible principle. That is what creates the sandbox within which the agency must play. Outside of that sandbox, the agency has no power to regulate. The biggest limit on agency discretion, even more so than the Constitution, is the agency's implementing statute. So that is the statute Congress passes to create an agency, along with other statutes related to an agency's duties. So the implementing statute is where agencies get the bulk of their authority. So for instance, Dodd-Frank created the Consumer Financial Protection Bureau and tasked it with carrying out certain duties, such as setting up a consumer complaint hotline and prohibiting unfair, abusive, and deceptive actions by financial institutions. These implementing statutes have to contain this intelligent principle through which Congress communicates its desire to obtain assistance through agency action. When agencies issue regulations through the rulemaking process, they have to be consistent with those statutes, consistent with congressional intent. Agencies do not have the authority to regulate if that authority is based on an unconstitutional delegation of power from Congress to the agency. So, for instance, Congress could not say, hey, EPA, figure out what to do about the oceans. That statement lacks an intelligible principle. Do what about the oceans? How? So as I said earlier, Congress has to create this sandbox in which the agency is allowed to play. And if Congress does not provide the sandbox, then its delegation of power to an agency is unconstitutional. It's overly broad, and it allows an agency to usurp the legislative power granted by the Constitution to Congress. Additionally, if an agency's implementing statute explicitly denies it the authority to operate in a certain area or denies it the authority to issue regulations, then the agency can't operate in that area and it can't issue regulations. And again, that's because agencies have no discretion to leave that box established by Congress. The FBI does not create laws about commercial space launches. That is beyond the FBI's statutory purpose, and it's also obviously better left to NASA. So any statute that tells agencies what to do or not do can further expand or limit the agency's sandbox, thus limiting or expanding an agency's discretion to act or not act. And the major statutory limitation on agency discretion is the Administrative Procedures Act, or APA. So after the New Deal, which brought forth a burst of agencies and agency action, Congress became concerned about sort of the expansiveness of agency authority and also about the separation of powers issue inherent in agencies. And President Roosevelt agreed with Congress that the agency's ability to exercise legislative, executive, and judicial branch authority was a problem. So neither the president nor Congress wanted unconstrained agency action because that would fly in the face of the Constitution. And thus the APA was born. And the APA really acts as an administrative Bill of Rights for all of us who are regulated by agency action. And that is basically all of us. It creates a framework that regulates agency action and thus limits agency discretion. So for instance, per the APA, agencies are required to keep the public informed of all of their organizations, procedures, and rules, regulations. Agencies are required to allow public participation in the rulemaking process. They are required to follow uniform standards for formal rulemaking and adjudication, and formal agency action is subject to judicial review. Now, the APA does not provide concrete time limits for agency action. It leaves most of this as deadlines for Congress to establish, if at all, in a particular agency's implementing statute. But even without a deadline, the APA states that an agency must, quote, proceed to conclude a matter presented to it within a reasonable time, end quote. So thanks to the APA, courts can compel agency action if the agency is unlawfully dragging its feet. And this is really important in the field of environmental regulations. So the APA provides individuals with a cause of action when an agency takes an unreasonable amount of time to act. But again, a claim of unreasonable delay can only be brought against an agency if the agency is legally obligated to take some action. So an agency must be required to act by law in order to establish a claim that says, hey, the agency has unreasonably delayed in taking that action. Another limit on agency discretion, as we've discussed, is the Congressional Review Act. So that was part of the GOP's contract with America back in the 1990s, but it was signed by a Democratic president, Bill Clinton. And the Congressional Review Act allows Congress to engage in the expedited review of new federal regulations, and it allows Congress to overturn any of these new regulations by passing a joint resolution. So again, both houses of Congress have to agree. The Congressional Review Act also prohibits an agency from reissuing a substantially similar regulation. So if Congress strikes down a regulation pursuant to the Congressional Review Act, the agency can't just go ahead and reissue it unless Congress specifically authorizes it to do so by passing a subsequent law. Now, prior to 2017, the Congressional Review Act was successfully used only once, and really very few people tried to use it. But after the 2016 presidential election, Congressional Review Act just took off. So the 115th Congress actually used that act 16 different times to roll back Obama administration regulations, even the ones that were supported by years of scientific study and popular with the public. So some examples of regulations, environmental regulations rolled back include the Department of Interior's Stream Protection Rule, some Bureau of Land Management regulations that established procedures that were used to prepare, revise, or amend land use plans pursuant to the Federal Land Policy and Management Act. It rolled back Department of Interior regulations relating to takings of wildlife, public participation, and closure proceedings for the national wildlife refuges in Alaska. So the Congressional Review Act allows Congress to check agency discretion. But what is Congress checking? The most common forms of discretion exercised by agencies relate to enforcement decisions, issuing regulations, accepting claims and applications, ordering protective actions, and performing tests or inspections. Prosecutorial discretion within agencies is similar to our popular notion of prosecution in criminal law. Instead of criminal enforcement, agencies provide administrative enforcement of laws. The outcomes can be just as unpleasant if you are on the receiving end, because individuals or corporations can be charged with a crime and with an administrative violation. Much like criminal prosecutors, agencies have a lot of freedom when it comes to setting their enforcement policies or priorities and allocating resources towards those priorities and making strategic enforcement decisions. So generally, agencies have discretion in deciding whether to enforce a statute or regulatory scheme. And this discretion stems from a combination of the president's constitutionally assigned obligation to make sure that laws are faithfully executed, and the Administrative Procedures Act's command that courts avoid reviewing discretionary agency decisions. So discretionary enforcement activities can include a range of actions, so including but not limited to the imposition of penalties, the initiation of an agency investigation, a lawsuit, or an audit. And prosecutorial discretion is a very big issue in some cases, particularly immigration and state legalized marijuana. So immigrants brought to the U.S. as children, popularly known as dreamers, have relied for a long time on the Department of Justice's discretion not to enforce immigration laws. And marijuana dispensaries that are operating in now 30+ states have relied on the Department of Justice's discretion not to enforce federal drug laws in states where marijuana is legal. So the DOJ, which is an executive branch agency, handles criminal and civil prosecution. Other agencies handle administrative prosecution. Regardless of the form of prosecution, agencies make decisions on whether or not they're going to investigate a violation based on a number of factors. And that includes the expense or inconvenience of opening and completing an investigation, and that includes the inconvenience of being in the court of public opinion. They also consider the likelihood of discovering a violation. Agencies are not going to waste time and resources if there's a good chance they're going to come up empty-handed. And agencies examine the expense or inconvenience of enforcing the law if the agency does find a violation. And that's because there's no reason to investigate if you're not actually going to remedy violations that you find during your investigation. So it's incredibly rare for an agency to be forced to launch an investigation. Unless Congress passes a statute that requires an investigation, the agency generally gets to make that decision on its own. It's got the discretion. Much like the decision to investigate, the decision to enforce a law depends on the availability of resources and the seriousness of the offense. So for example, with regard to availability of resources, the DOJ did not want to get mired in lawsuits with 30+ states over medical marijuana, and so the DOJ made enforcing federal marijuana laws the lowest priority, especially in states that had legalized it. Agencies can also delay enforcement. So there are times when the underlying law takes legal effect and conduct that violates the law remains unlawful, but the agency, in an exercise of its enforcement discretion, does not take action in response to violations, or at least it delays taking action. So, for example, a provision of the Affordable Care Act had required health plans to meet certain minimum coverage requirements by January 2014, but the Center for Medicaid Services announced up front that it was not going to enforce those requirements for health plans for at least a one-year period. And generally, the delay in enforcement is to allow the public, both people and organizations, to come into compliance. In situations where an agency refrains from bringing an enforcement action, courts have been pretty cautious in reviewing the agency's determination. And that's because agencies really are better equipped than courts to evaluate the many, many variables involved in determining agency priorities and how to expend limited agency resources. There are also some reasons why courts are not really suited to review an agency's decision not to act. So first, agencies' decisions on whether or not to initiate enforcement actions, those are usually based on a really complicated balancing act. Agencies consider multiple factors like efficient allocation of limited resources, likelihood of success, and the relationship of the potential action to the overall enforcement strategy of the agency. Obviously, because all of that analysis is taking place within the agency, agencies are better suited than courts to performing that analysis. Second, courts have noted that when an agency chooses not to act, the agency is not exercising any coercive power over others that would be worthy of heightened judicial protection. And third, courts have held that an agency's decision or discretion not to seek enforcement, that's pretty similar to the historical ability of prosecutors when they decide that they're not going to seek an indictment. And courts have traditionally been really unwilling to review that. But the courts have emphasized that this presumption of unreviewability of agency inaction can be rebuttable. So if an agency decides not to act because it believes it lacks the jurisdiction or authority, or where an agency consciously and expressly adopts a policy that is really extreme, so extreme that it represents an abdication of its statutory responsibilities, then courts can get in there and review the agency inaction. But like we saw earlier, it's very hard to address agency inaction in court. Agencies also have discretion when it comes to making decisions to negotiate settlements. So much like U.S. attorneys or district attorneys, agencies do have really large caseloads. And engaging in negotiation and settlement, that helps avoid the time and expense of pretrial procedures and also the trial itself. Now, the Administrative Procedure Act does impose some limits on an agency's settlement discretion. The APA requires agencies to at least consider settlement offers. So the agencies can't just blow them off. They've got to at least consider them. And the APA tells agencies that they do need to settle when time, the nature of a proceeding, and the public interest allow. Now, although agencies must consider settlement proposals, they do have the discretion to accept or reject them, so long as they have considered the public interest. And that includes the effect of any settlement on consumers, regulated parties, and others. If an agency establishes internal rules relating to settlement decisions, they have to follow those rules too. So agencies can actually further limit their own discretion. Together with prosecutorial discretion, rulemaking discretion is the most important form of agency discretion. And we are going to talk a lot more about rulemaking in coming weeks. So here I'm just covering it as it relates to agency discretion. So Congress regularly authorizes and requires agencies to implement and enforce regulatory programs. That means that agencies routinely make decisions about when to create regulations, when to enforce statutory requirements, and so forth. And while an agency's actions cannot exceed its statutory authority, again, we go back to that sandbox created by Congress, courts do tend to defer to agencies' decisions. So let's talk about that for a moment. So this concept of deference to agency decisions. It comes up a lot in administrative law, and it is really just a gauge of how willing a court is to defer to an agency's decision. So agencies make these decisions on how to interpret statutes that affect their missions, how to interpret the regulations they create, and how to provide informal advice to those outside the agency. They make those decisions all the time. And all of those decisions are based on the agency's opinion about its role in setting and enforcing policy. So the concept of legal deference is the amount of weight that a court will give to an agency's opinion. As individuals, we would likely defer to an oncologist about cancer treatment plans. The oncologist is a cancer expert, and so we would give her opinion a lot of weight. It's meaningful to us, and we accept it as valid. Courts make that same type of reckoning when it comes to agency opinions. If a court defers to an agency, the court will provide oversight of an agency action, but it's not going to substitute its opinion for the opinion of the agency. So if the agency chose to implement Plan A, a court will check to make sure that the agency has the authority to implement Plan A, but a court will not order the agency to instead implement Plan B. If the court does not defer to an agency, it can completely disregard the agency's decisions. So in that case, a court could order the agency to implement Plan B instead of Plan A. And there are several different types of deference. So agencies are in the executive branch, and the judicial branch is entitled to review executive branch actions. We're going to cover judicial review in a lot more depth later in the course. But for now, it's just important to understand that courts do review agency actions, and they do so using 3 different standards of deference. And each of these standards gets its name from a court case. So first up is Chevron deference, where courts give substantial deference to an agency's interpretation of its own statutory authority. So this comes to us from the 1984 Supreme Court case, Chevron versus Natural Resources Defense Council. And Chevron is the most important case in administrative law, and thus in environmental law and all hazards management law. Chevron deference assumes that if Congress did not give the agency specific instructions to follow, then courts should defer to an agency's interpretation of the statute that it's administering, as long as its interpretation is reasonable. Second, we've got hour deference. So it's spelled A-U-E-R, but it's pronounced like an hour of time. And this deference comes to us from a 1997 Supreme Court case, Auer versus Robbins. In hour deference, courts give agencies substantial deference when it comes to the agency's interpretation of its own regulations. So remember, Chevron is about statutory interpretation. Auer is about regulatory interpretation. So pursuant to Auer, courts defer to an agency's interpretation of its own regulations unless that interpretation is clearly erroneous. But it only applies when the language of the regulation is ambiguous and the agency's interpretation is not clearly wrong. And this form of deference has actually been a little bit more limited by a case called Mead that we will discuss in a moment. Third up is Skidmore deference. That comes from a 1944 Supreme Court case of Skidmore versus Swift and Company. And in Skidmore deference, courts must respect an agency's interpretation of its authority as long as the agency's interpretation is persuasive. So for this reason, Skidmore deference is often referred to as the power to persuade. So if Chevron and Auer deference do not apply to a case, then Skidmore deference does. And back in 2012, a Supreme Court case involving the EPA, called Decker versus the Northwest Environmental Defense Center, confirmed the idea that courts should defer to an agency's interpretation of that agency's own regulations unless the interpretation is clearly erroneous or inconsistent with the regulation. So Chevron was a landmark case. This is where the Supreme Court set forth the legal test for determining whether or not to grant deference to an agency's interpretation of a statute that it administers. And Chevron didn't really change anything. It just clarified the approach that courts were already using. The facts of Chevron dealt with amendments to the Clean Air Act that were designed to address the states that had failed to attain air quality standards established by the EPA. So through the Clean Air Act, states had to establish permit programs that regulated new or modified major stationary sources of air pollution. During the Carter administration in the late 70s, the EPA defined this source of air pollution as any device in a manufacturing plant that produced pollution. Then, during the Reagan administration, which followed the Carter administration, the EPA decided to adopt a new definition that allowed existing manufacturing plants to get permits for new equipment that did not meet those EPA standards, as long as the total emissions from the whole plant did not increase. The Natural Resource Defense Council challenged the EPA's decision to change definitions, challenged them in court, and won. Chevron Corporation was affected by this issue, and so it appealed the lower court decision. And as a result, the Supreme Court gave us the Chevron two-step test. So step one, does the statute show a clear intent of Congress? Sometimes this is phrased as, is there a statute on point? And if yes, the courts give no deference to the agency. The agency must follow congressional intent. But if the statute does not show the clear intent of Congress, then you move on to step two, which is the question of whether the agency's interpretation of the statute is reasonable. And if yes, the court gives deference to the agency and it allows the agency's interpretation to stand. But if the court finds that the agency's interpretation is not reasonable, then the court itself interprets the law and tells the agency what to do. So here is just the Chevron two-step test in flowchart form. You see the start, is there a statute on point? If yes, courts don't defer to the agency. Agency has to follow the intent of Congress. But if no, then courts defer to the agency and they'll review agency actions in one of two ways. So courts ask whether or not Congress has explicitly delegated to the agency the authority to fill gaps. If yes, then the court reviews the agency action or regulation using either an arbitrary and capricious standard or a substantial evidence standard. And we're going to talk about those standards of review later in the semester. If Congress did not explicitly delegate that authority to the agency, then the court simply reviews the agency regulation or action to make sure that it is reasonable. The United States versus Mead Corporation case addressed the issue of when and where the Chevron doctrine should apply. So this case basically created Chevron step 0. And so in this particular case, the Mead Corporation, which makes day planners and calendars, it challenged a U.S. Customs ruling that had classified its day planners and calendars as diaries and notebooks that were subject to a tariff. So before Mead, it was clear that the Chevron doctrine applied to interpretations of things that had the force of law, so regulations and formal adjudications. But lower courts weren't sure whether it applied when the agencies did something that don't really carry the full force of law. And in this case, the U.S. Customs tariff rulings were made on a case-by-case basis. They didn't have any precedential value, so nobody was going to rely on any particular ruling going forward. And thousands of these rulings were made every year by 46 different regional offices. So the court found that these rulings were not worthy of Chevron deference and instead kicked it back to the Federal Circuit Court to determine if those customs rulings were entitled to Skidmore deference. So again, this just changed the start point to see whether an agency's action has the force of law. And if not, you ignore Chevron deference and you apply Skidmore. But if it does, then you move on to that whole Chevron flowchart. So before Mead, the Chevron doctrine applied to interpretations that were adopted in agency regulations and in formal adjudications. Because the lower courts disagreed about whether or not Chevron applied to interpretive rules or policy statements, advisory letters, that's why the Supreme Court weighed in Mead. And in Mead, it determined that informal agency interpretations are not treated the same way as regulations. They're not preceded by notice and comment as required by the Administrative Procedure Act. They don't carry the force of law. They're not intended to clarify the rights and obligations of all individuals or organizations. They only apply to one specific case. And so because of that, they're not subject or they're not worthy of Chevron deference. Okay, another form of agency discretion relates to claims and applications. Most agencies process various claims and applications. So, for example, Centers for Medicare and Medicaid Services, they process medical claims for payment or reimbursement. The National Science Foundation processes applications for funding. The EPA processes applications for permits. Each agency can determine its method for processing these claims and applications, so long as those methods do not violate the due process and equal protection clauses of the U.S. Constitution, which we will discuss later this semester. Moving on to another example of agency discretion, agencies can engage in protective actions. So we have some agencies that exist to protect the health, safety, and financial well-being of the public. And those agencies have discretion to take protective actions. So example, there are recalls. The FDA can recall meat or spinach that's contaminated by E. coli bacteria. Agencies can seize goods. The Consumer Product Safety Commission can seize a shipment of lead-based toys from China before they get to the US. Some agencies can suspend professional licenses. State Bar Association can suspend an attorney's license to practice law, for instance. And agencies can engage in actions to enforce civil penalties, basically making people pay fines. So agencies that are permitted to engage in protective actions have a lot of discretion to determine when, where, and how to do so. The last form of agency discretion we'll discuss today is about tests and inspections. Much like some agencies exist to engage in protective actions, others are authorized to establish testing and inspection requirements. So for example, the EPA tests water for contaminants. There are state agencies that test vehicles for emissions or test applicants like lawyers and doctors for professional licensing. Issues relating to the validity or the reliability of the testing procedures can be challenged. So if you think that a particular test is not reliable, you can challenge the test. What you cannot challenge are agency decisions about whether to test and where to perform the test. Those decisions are left to the agency's discretion. Okay, so there are a few points that I hope that you'll take away from this lecture. First, vague and/or competing goals lead to discretion. Sometimes Congress can't or won't clarify its goals, and thus it implicitly grants an agency discretion to resolve the policy dilemma by allowing the agency to make its own choice. Second, discretion is inevitable, and it actually does contribute to democratic public administration. Discretion enhances public service competence, by infusing agencies with energy and capacity for change. And it promotes political responsiveness. Public officials have to decide between competing interests and values. And we don't want those decisions to necessarily be replaced by systems of black and white rules. And third, for better or worse, discretion makes individual moral responsibility possible within public administration. All right, that is it. Thank you so much for sitting through a relatively long lecture. I've got one thing due this week. That's discussion 1, getting to know you. It's ungraded, but you do have to complete it because I want to know what you hope to gain from the course. And I want you to think ahead about some news items from year 2040. A lot of you have already posted your discussion post, so you're not required to post anything else, but do please feel free to interact with your classmates. Thank you again for sticking through this long lecture, and I will see you on the discussion boards.